I beg to mention item number 3 of today's list, Lordship.
3.
3, Lordship.
Hmm.
Lordship, may kindly pass over the matter for a day, Lordship.
Okay. On the prayer of
M.K. Das, Lordship.
Mr. M.K. Das, Learned Legal Aid Counsel, for the appellant. Case is passed over for the day.
Deeply obliged, Lordship.
Please, Your Lordship, with the consent of the other party, I beg to mention item 19.
From 19 years. You are for?
D does,
Okay.
sole respondent.
You have informed the other side. MS.
TINLUNG Tinlung.
Okay. Abdul Lobo. Learned Counsel appearing for Mr. D. Das. Learned Counsel for the respondent. Has. Yes, what is your prayer?
For adjournment, Lordship.
Huh?
For
For
adjournment.
how much period?
For a week.
Okay, let's wait for an adjournment. Let's wait for an adjournment of a week. It is submitted that consent has been taken from the Learned Counsel for the appellant, and a mentioned memo to that effect has also been circulated. Full stop. The price allowed is the case after a week, on a day 2 weeks by the office. Yes.
May I please, Your Lordship? Lordship, I beg to mention for listing of one appeal, Lordship, against Equitel, Lordship. Earlier, it was listed on 24/7/24 before the.
For admission or what?
For admission, Lordship. It was earlier listed and the Honorable Court, Lordship, directed registry to list before the appropriate bench. Lordship. But
It will
till-
come now. Why, Harry? If it is registered, it will be listed as immediately as possible.
No, it was last, Lordship, last posted on 24/7/24.
Check up whether defect is there.
There is no defect, Lordship. There is a confusion, Lordship, that whether this matter relating to division bench or single bench. Lordship.
What is the offense?
Offense is 30, acquittal under section 302, Lordship,
Ah.
and as per High Court rules, Lordship, if Lordship, the person acquitted from charge under 302, then it will,
Yes.
Lordship.
I don't think there is confusion. Appeal against
No,
acquittal is.
Earlier, Lordship, it was listed before the single bench, Lordship.
No, appeal against acquittal, we are hearing, we are admitting.
Wrongly listed, Lordship, there, and last occasion, Lordship, I point out before this Honorable Court, Lordship, this matter relating to division bench, so Lord, this Honorable Court may direct the registry to list before appropriate bench.
Cases against appeal against acquittal, those are listed
For the division bench.
almost usually. There is no confusion in the registry, Mr. Choruri.
Lordship, earlier.
No. We have been last
No,
3
Lordship, this,
months, we have been seeing that we are admitting appeal against
Lordship, this
acquittal
matter,
against 302.
Lordship, this matter listed earlier before on Lordship 24/7 in single bench, Lordship. That's why I'm Lordship paying for listing.
Okay.
Deeply all right.
May it please, Your Lordship. Lordship, with regard to item number 20, my lord, this matter may kindly be taken up after 1 week, my lord. Today, my senior has some personal difficulty, my lord.
Why?
Item number
You
20.
should have mentioned it.
Lordship, we have taken the consent.
No, consent is not the, what is written there?
No, my lord, this is advance. I'm sorry, my lord, from.
It is written there,
Lordship.
lister published long back on Saturday. You could have mentioned it. Okay, we wait, then we'll see.
Daily list for admission. I don't know, one.
May I please, Your Lordship? Lordship, this is statutory appeal challenging the judgment dated 2/2/2024 passed by the learned Special Judge Bongaigaon in special NR case number.
Heart, Mr. Choruri. Legal Aid Counsel,
Yes, Lordship.
Learned Legal Aid Counsel. For the accused appellant and MS A. Begum. Learned additional public prosecutor for the respondent state. Full stop. This criminal appeal is directed from jail, is directed against a judgment in order dated 2/2/2024 passed by the Court of Learned Special Judge Bongaigaon in special within bracket NAR case number 05 within bracket BGN of 2023. Full stop. By the judgment and order dated so and so. The accused appellant has been convicted for the offense under section 22 within bracket small c of the Narcotics, Drugs and Psychotropic Substances Act 1985, and he has been sentenced to undergo rigorous imprisonment for 12 years and to pay a fine of rupees 1 lakh. In default of payment of fine, to undergo simple imprisonment for another 6 months. We have perused the contents of the memorandum of appeal. The criminal appeal is admitted for hearing. The records of special so-and-so case number we call for issue notice returnable in 4 weeks as MS Begum, learned additional public prosecutor, has appeared and accepted notice on behalf of the respondent state. Issuance of formal notice to the said respondents and dispense with extra copy. Release the case after 4 weeks.
Oblige, Lordship. Lordship, there is a I.
I
After.
let LCR be
Oblige.
received.
Item 2,
May I please, Lordship?
Legal Aid Council
Lordship.
had MS the Borpujari, learned Legal Aid Council for the accused appellant, and MS A Begum, learned additional public prosecutor for the respondent state of Assam. A criminal appeal is directed against Agorton Ismail. Judgment and order dated 21/3/2024. Session Judge Jorhat. Sessions case number 85 within bracket J-T stroke 2019. By the judgment and order dated so and so, the accused appellant has been convicted for the offenses under section 302 IPC and section 364 from IPC. For the offense under section 302 IPC, the accused appellant has been sentenced to undergo a rigorous imprisonment for life and to pay a fine of rupees 100,
Lordship.
in default of payment of fine, to undergo rigorous imprisonment for another 1 month. Full stop. For the offense under section 364 IPC, the accused appellant has been sentenced to undergo rigorous imprisonment for 6 years and to pay a fine of rupees 1,000, in default of payment of fine, to undergo rigorous imprisonment for 1 month. Full stop. It has been ordered that both the sentences are to run concurrently. Full stop. We have perused the contents of the so-and-so. Admitted for hearing. Case records of call for issue notice returnable in 4 weeks as MS Begum. Take the case after 4 weeks.
item number 4,
Wait, please, Your Lordship. This is an appeal against conviction under 302 Lordship caused by the
Hard. How many?
Lordship life
Two.
imprisonment. Lordship two appeal.
Hard Mr. B. Chaudhary. Learned counsel for the accused appellants. NMS A. Begum. Learned additional public prosecutor for the respondent state. Full stop. This criminal appeal is directed against a judgment
18/11/2023.
an order dated 18/11/2013.
23 Lordship.
22 or 23?
23 Lordship.
Passed by the Court of Learned Sessions, Judge Lakhimpur at North Lakhimpur. In Sessions case number 78 within bracket NL of 2013. Posted by the judgment and order dated so and so, 3 accused persons, including the present 2 accused appellants, right?
Yes, Lordship.
have been convicted for the offences under sections 341 stroke 326 stroke 302 stroke 34, Indian Penal Code. Full stop. For the offence under section 302, IPC, both the accused appellants have been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 15,000, in default of payment of fine, to undergo simple imprisonment for another year. Full stop. For the offence under section 3, for the offences under 326 IPC and section 341 IPC, both the accused appellants have been sentenced to undergo different terms of imprisonment. Full stop. It has been ordered that the sentences would run concurrently. Full stop. We have perused the contents of the memorandum of appeal. And the criminal appeal is admitted for hearing. Records of so-and-so be called for, issue notice returnable in 4 weeks as MS Begum appeared, accepted. No formal notice, formal notice dispensed it.
Lordship, I.
Served to us, Lordship.
Huh?
We have not received the copy, Lordship. Additional copy.
Okay.
We have already serviced. Okay.
No, it is not in the office. We have not received.
Art Mr. B. Chaudhary, learned counsel for the applicant appellant, and MS A. Begum, learned additional public prosecutor for the opposite party state of Assam. Full stop. The instant application is preferred by the appellants seeking suspension of the execution of the sentence passed against them and for their release on bail. Full stop. The applicants, as the appellants, has preferred the accompanying criminal appeal against the judgment and order dated so-and-so, so-and-so. Issue notice returnable in 4 weeks. Mr. B. Chaudhary, learned counsel for the applicant, shall furnish a copy of the application to MS Begum, learned additional public prosecutor, within 2 working days from today. So stop. The applicant, the respondent, opposite party state shall file its objection to the interlocutory application on or before the returnable date.
Highly obvious.
Item number 5.
Lordship, it is appeal against the conviction and order dated 4.
Mr.
K. Thakur, my lord.
Hart, Mr. K. Thakur, learned counsel for the accused appellant, NMS A. Begum, learned additional public prosecutor for the respondent number 1, state of Assam. Full stop. This criminal appeal is directed against a judgment an order dated 4/11/2023.
My lord, it should be 412, my lord.
4/12,
Yes, ma'am.
4/12. Okay, within bracket incorrectly mentioned as 4/11/2023. Passed by the learned, perhaps by the Court of Learned, Additional Session Judge, cum Special Judge, POXO, Kamrup, Metro, Guwahati, within brackets, the Special Court for short. In Sessions case number 300 of 2017, which arose out of Gorsuk Police Station case number 89 of 2015. Order dated 16/8/2024 of the Law Jima Court. Service of notice upon the respondent number 2 is complete. First, where the offense involved, and none has appeared for the respondent number 2. till date. Full stop. The offense involved is section 302, IPC. Full stop. As the paper book is ready, office to release the case for hearing in due course.
Item 7,
May I please, Lordship? I have received the paper book, Lordship. Case is ready for hearing.
Offense,
302, Lordship.
okay, hard MSD, Bor Pujari, learned legal counsel for the appellant and MSA Begum, learned additional public prosecutor for the respondent state. Full stop. As the paper book is ready, office to list the appeal for hearing in due course.
item 8,
Receive the paper book, Madam.
Prime Doctor learned amicus brief for the appellant and MSA Begum, learned additional public prosecutor for the respondent state. Full stop. And the paper book is ready and the learned counsel for the parties have already received the copies of the paper book, office to list the appeal for hearing in due course.
item number 9,
May it please, your lordship. My lord, the office note dated 19/8 shows that my lord service upon the respondent number 2 is not completed, my lord.
This is duly served on 31.
Duly served. Okay, we appoint one legal aid
Yes,
counsel, then we'll proceed.
Yes.
Heard Mr. Asdas, learned legal aid counsel for the, learned counsel for the applicant appellant. And MS A Begum, learned additional public prosecutor for the opposite party number 1, state of Assam, full stop. It has been informed by the, by the learned additional public prosecutor on the previous date of listing. That is, on 31/5/2024, that the notice has been duly served upon the respondent number 2 dash informant. Full stop. The respondent number 2 was found unrepresented on 31/5/2024. Full stop. It was then observed that office was directed to verify and submit a report as to whether any counsel representing the respondent number 2 has already filed power or not. Full stop. As per the report dated 19/8/2024, none has appeared for the respondent number 2. Full stop. In view of the above fact situation, we deem it appropriate to appoint madam. Madam. Millimeter. Sumit Biswas, learned counsel from the panel of legal aid counsel to represent the respondent of opposite party number 2. Opposite party, that's respondent number 2. In this application as well as in the accompanying criminal case. First, the office to furnish the necessary case papers to Mr. Biswas within 1 week from today. List the case after 1 week.
Highly hopeless.
Next to bail.
Items 10 and 11.
Met your lordship. That matter might have already your lordship. That.
89.
Put in
But
code.
formation of the bench was different then.
Oh, of course, my lord.
So you please apprise us the brief bullet points at
Yes,
least.
your lordship kindly say that we have given the compilation, it may be there, it will help us, man. But who accused in the case, your lordship kindly FIR might have page 1. Again, we have to start from beginning, my lord. That might have, that the person has taken the girl from the house, then he kept in his house, thereafter she got missing. Subsequently, it has realized that might have this, both the person have killed her. But doctor found that
Charge is only 302.
302. 201 and 302.
201 also.
Yes.
Conviction? 201 also.
Yes, conviction is my lord. Yes, 201 also. 302, 301. So now might have total 15 might have
15 witnesses were examined.
examined. But so far the present petitioner is concerned, item number 10. We find might have except one that is 8 my lord, PW8 who was declared hostile, but in the hostile party your lordship last time almost convinced my lord that there is a fair chance of acquittal. That government of 389 will be applicable in my case, my lord. That was the observation your lordship also made on the other day. So father of the girl, my lord, if you also kindly see, father of the girl, PW5, kindly have a look to PW5, my page 11 to 12. Your lordship. Now, cross examination by defense for Sottagali.
318 to sound.
Page 11. Cross examination by for Sottagali. I did not lodge the Ajhar. Your lordship got it, man. I did not. Ajhar was lodged by his brother, man. The dead body of my deceased daughter was recovered after 4 days of her missing. The place of occurrence is at a distance of 160 cubits from the Bilashipura pier. There are 4,000-5,000 villages in our village. Prior to the incident, your lordship kindly say, my daughter was working in a brick factory situated near the house of so-and-so. I sent my daughter Ashabanu to the house of Sottagali, your lordship kindly know. Sottagali with my 2 sons, Rafiqul and Shafiqul. Till my arrival in the house of Sottagali, my two sons were in the house of Sottagali. They told me that Ashabanu was, name of the deceased man, was missing without their knowledge and she did not return back to the house of the accused. Hassan Ali Mandal is my brother. He has lost the FIR, man. And his house is situated at a distance of 2-3 Roshi. I did not visit the place of occurrence.
What is Roshi?
Roshi, my lord, it is normally Dubri side. Roshi, my lord, one Roshi about 20 meters, something like this. One Roshi. I do not know. I did not visit the place of occurrence at the time of recovery of the dead body. I do not know how the dead body was recovered. It is not a fact that the recovered body was not the dead body of my daughter. I do not know the law. The law is PW, my lord, 9. It is not a fact that my daughter did not go to the house of the accused with my 2 sons. It is not a fact that I did not go to the house of the accused. accused Sattakali has two sons and one daughter in his family. I saw the wife of Sattakali in a position of pregnancy. It is not a fact that the accused Sattakali did not know about the missing of my daughter. It is not a fact that I did not tell my brother Hashim Ali about the missing of my daughter. Even I did not tell anybody about the missing of my daughter. I have good relation with Sattakali. I have not seen the murder of my daughter. It is not a fact that I am deposing falsely against the accused Sattakali. Cause for Rahimuddin decline. So there is no whisper against Rahimuddin, my lord. My only question is also other day, you also might be remembering, my lord. So FIR also says, my lord, Sattakali has taken. Thereafter in the FIR it is stated that my lord Sattakali and Rahimuddin killed her. But that is not supported by PW1 also, my lord, the informant himself, my lord. As your lordship has seen the other day. Now, the other persons, my lord, PW 5 and 6, 5 already your lordship has seen 5. Father of the deceased, your lordship already seen. Then 6. 6 also, my lord, he is a brother. Yes, 6 also brother of the informant, my lord. He also did not implicate Rahimuddin. Then Dr. my lord. What do you mean? 22, 23.
Filed.
My lord?
Any missing complaint was filed.
No, my your lordship kindly see.
See, father of the girl,
No,
father of the girl went to
PW 5
went to Sattar's house
house.
on 12/6
Right.
as per the FIR. As per the FIR.
As per the FIR.
Then on that day, father was informed that the girl was missing since 11/6. Then on 14/6, the body was found
Yes.
floating in a river.
And on 14 FIR also lost.
Then FIR was
In
filed.
the same day.
So any missing thing was
I do not find my
entry.
I
Let
do
us see the IOs.
yes,
Just for a moment.
PW 13 my 13 is in 27 30. You might have actually in fact from PW 11 to 14 all are IOs my.
Let us see. Just have a glance.
Yes.
PW
It's IO starts from PW 11 my.
11.
Page 22. Those. Are you
Entry was there, your lordship,
Yes.
case 23,
Hmm,
13-6. It was on 13-6. After the father of the,
12-6.
yes, 12-6 he arrived.
12-6,
Nothing has been
13-6.
done.
ZD entry 221.
It is, madam, the judgment, it appears also, page 37, paragraph 39. Oh, 39, oh, 40. GDNT number 221 dated 13/6/12. On the next day, Himani Mandal came to the outpost and informed the
ZD entry 221.
221 of 13/6/12.
Which place, page?
Page 37 of appeal.
30?
Judgment, my lords.
Judgment.
Judgment, paragraph 40, my lords.
40.
Page 40.
Paragraph 40.
40, your lordship will find. W12, yes, sir. 12,
It was Sattar Ali.
yes. Father is not. Because she was missing from his house. And he is the person who brought her to his house.
Now, what is the finding against this applicant?
Applicant, madam, finding is extrajudicial confession, man.
Which part?
That part your lordship will find the judicial confession. See? Paragraph 71 of the judgment.
Para?
71. 71. Yes. Only on that basis, my lord, this conviction was there.
There are 74, your lordship. They had no inimical terms. There are 74 of the judgment, page 94,
Yeah.
74.
70. Saptagal is father. 73 also your lordship. Man.
1 minute.
It starts from
1 minute.
Yes.
Who gave 164 statement?
PWA, huh? PW
Dilbar.
Dilwar. Dilwar is PW9. And that was after 11 months, man.
That is one, and one, what is 72?
Yes.
Paragraph 72.
Paragraph 72.
Extrajudicial confession.
Judicial confession. Dealing with Supreme Court judgment, its statement of that is about the judgment mentioned, madam. That paragraph so and so, showing that
Mohammed
It
Azad.
says that my regular test is required in case of swan.
Mr. Azad. Liability of the witness.
Page 73 also, your lordship, I'm
Not open to any go to start we can it will depend on. Para 81 is the conclusion.
Para 81.
Rohimuddin and Sattar were not seen together.
No.
Lordship, there's a.
Rohimuddin and Sattar were not seen together. Nobody had seen. Rohimuddin and the deceased was also not seen by anybody. To bring in the theory, even last scene, nobody had said. The lady was missing from Sattar's house. Say on 12. 13, Sattar lodged a GD entry. 14, father visited Sattar's house. Came to know that his daughter was missing. Then, on that day or whatever, oh no, not 14, he visited 12.
Father visited on 12.
CD entry on 13.
Yes.
Yes.
And there is some evidence that both Sattar and father were looking for the guard. I think father, let us see father evidence.
Yes. PW 5.
PW
5 man.
5.
Azhar Ali Mandal 11, 12. 8. After 4 days, he went to the house of in the chief mine. On being asked, Saptag told me that he does not know.
Father visited.
He said, my lord.
13th
uh,
ZD entry by Sattar about missing. 14th dead body was found floating. And there was nothing about Rohimuddin. But it was PW 9.
PW 8 also.
it
8 is
was
who?
declared hostile, my lord. that's all.
Maybe, but it
Yes.
was like.
Yes, yes, that we have last time she pointed in.
8.
But court did not rely on 8, my lord. Court relied on 9 and 10.
PW 8, your lordship.
Yes, it would have been better for prosecution
Yes.
to, after crossing this witness,
Yes.
to bring this to the notice of the IO,
Let
to
us
bring
see.
it on record, not as a, to bring it on record,
My lord.
marked portion
Lordship,
that we dealt with that some Kisavai something
Minor.
1954.
lordship. Lordship, whether, let us see whether it is put to the IU,
In the manner VK Mishra,
minor. Then-
perhaps not. Please have a look. Itu bisa tak? Ayah tak tahu. Ayah tak tahu deh. Ayah tak tahu ni deh. Contradiction to নহব আৰু এইটো ৰেকৰ্ডত থাকিব মাৰ্ক কৰি পেলাই এক্সিবিট কৰিব লাগিব আয়োগ তাত আনি পেলাই এক্সিবিট কৰিব লাগিব এইটো এনি আয়োগ চিধা ইট ইজ নট এ ফেক্ট বা ইট ইজ ট্ৰু বুলি এনেকৈ আনিলে নহব
Lordship. 26B. Second paragraph.
B.
In his statement made before me, witness Sanwar Hussain, his PW8, stated that accused Rahim Ali Hibuddin confessed before the people of the village about killing of Asmanu.
Where is
Sanwar,
that mark portion?
Lordship is typed out whether in the original. So on the last occasion, I made a prayer before his honorable court. So now, this one verse, evidences are in Varnicula. Let the entire matter be.
No, it can be seen from since we have proceeded to some extent.
Lordship, it was there.
Original-
Sanwar stated to me that Rahimuddin took Asmanu to the bank of the dead tributary and.
Oh, whether this has come on a record.
Yes,
He simply said in his statement made before me.
yes.
But where is the marked portion? And marked as for the purpose of contradiction.
Lordship,
Yes.
To bring it on record that this man stated before police like this. To bring it on record, I am saying.
my lord. So that is.
It is
a
not done.
irregularity,
That is why
Lordship.
trial court, not irregularity, this is fatal.
Lordship, let us see. in
That is
Varnicula's
why
version.
perhaps the learned trial court did not discuss PW8, did not rely on him. And there is a justified reason behind it. Then PW9. So we do not, cannot,
164 statement.
should not refer to this man. One 64.
That is PW.
You just, MS Bhuya. You just read paragraph 66.
Of the judgment.
I mean, original research, Varnicula. 164.
Is 90 minor.
Is 90.
Although defense during cross-examination brought it on record through PW9 that he has no knowledge about the actual incident and police produced him before the magistrate about 1.5 years back, he did not make statement before the magistrate of his own. It's also stated that he did not put signature, but it doesn't nullify the value of the statement of the state witness given before the magistrate under 164 CRPC because
Is the magistrate testified?
No,
Magistrate did not testify.
not again.
And 164 statement. I think
His signature, he said
we-
his signature, he did not put his signature on it.
Yes, the last occasion, I think we have seen,
Last time you was gone through each and every line of
Uh-huh.
the 164.
I think 164.
Page
Uh,
A is the minor 164 statement.
is
18A, capital A.
88. What is his name?
His name is
His name
Dilwar
is
Ali.
Dilwar.
Dilbar,
Dilwar Ali.
Dilbar.
My lord, Dilbar.
He said, who should have, the same person. PW.
One sixty-four to 40, sir.
164 page. 15.
কারণ হিন্দি কইছে ন PW Dilbag
9.
9.
Page 19, your worship, see. He said that he did not put his signature even on that.
নিজে প্রসাদ কইছে সই বানাবে বলে
Lordship.
We have seen the original, no signature. He said in PW 9 cross,
Yes.
I did not put any signature. This is one of the circumstances relied.
The learned part.
That at best, it could be a corroborative evidence, not the main. Then next one is PW 10. PW 10, what did he say?
PW
He
10.
said regarding confession.
On that
extradition.
night, accused Rohim Ali took away Asbanu from the house of my son Sattar.
He is the father of Sattakal.
On the next day, villager apprehended accused Rohim and Rohim confessed before in presence of villagers that he had killed Asbanu. When accused Rohim confessed killing of Asbanu, I was present. Then
Then page 21, last part, your worship.
village people disclosed that
Yes.
Rohim confessed killing Asbanu.
Who is that village people?
It is not a fact that I did not hear the accused Rohim confessing murder of Asbanu.
And he reiterated it was confession was also made before him. And your lordship will kindly know he is the father of Sattar.
Who in order to save his son, my lord, he indicated the petition. Last part, page 21, man.
Sindipara. Ipara.
I did not see accused of him coming in the house of the accused Satta. I did not see accused of him taking away Asabano. Now the accused
My
Satta.
house is Kothaldi. Kothaldi. He is father of
Father of
Satta.
Satta.
Lordship, it
Father
is
is
not,
Sattar.
yes. It is not a fact that I did not make statement before the police. The accused Rohim made confession before the villager and before me. And your lordship, extrajudicial confession part, whatever has been stated by Rohim, that he tied gamusa on the neck of the deceased, corroborated when the dead body was found.
No, what is the extra? This is the only part. Gamusa, all these will not come into record. Even if we accept
My
for a
lord.
timing that this extrajudicial confession is admissible,
My lord.
then all those tying up, all those will not come.
Exculpatory part.
No, it is not there. It is not there. He has only heard confessing killing. He did not say about Gamusa and all. Body was found with a Gamusa.
Yes,
That is
Lordship,
different
it
matter.
was in the evidence of PW8. Since your Lordship, learned tried to discard it, it was not as per norms. What should have been followed? It was there.
PW8 and PW10 perhaps have not added anything to the case of the prosecution perhaps.
But your Lordship, extrajudicial confession was also.
Only
made before
PW,
it.
this species only is remaining. That is also only this species remaining regarding Rohim.
Regarding Rohim,
But this is to be
Sattar, as regards Sattar, they, on the last occasion, they have made submission before this honorable court. They don't deny that they have taken away the guard from
no,
the
this is Sattar.
Sattar.
No, we are on
Sattar has
Rohim.
taken away. Sattar has taken away 313 silent about Sattar that they have taken away. Remain silent. As regards Rohim, he made extrajudicial confession before the father of Sattar, as well as to another person, PW9, which your Lordship probably will not accept it. But your Lordship, they have surrendered subsequently before the police station. Why there was, if there is no like, why they are to Lordship surrender? Why they were apprehending arrest?
They are named in the FIR.
Named in the affair also.
Yes. They have to apprehend.
At that time, nobody was aware. I don't know what transpired, but so far. Taking away Asbanu from the house of Sattar,
Yeah.
the two brothers of Sattar, two brothers of the lady,
Sabanu.
Asabanu, was very much there. They were there very much.
Lordship, your Lordship will consider their age minor, 8 and 9 years, something like that. They might have deep sleep.
It was Sattar who was more answerable than Rohim.
He remains silent in 313.
More because the lady went missing from his house,
No,
apparently.
Lordship.
And I don't know, Rohim, whether he belongs to the same village or some. Same village or some
Sattar
different
address to
village.
CSO, দেখো। হ্যাঁ? কোনে কইছে তো? এই? এই?
What is possible to imagine
My God.
is different than what is brought on record. That is the difficult.
Lordship.
What is possible to imagine is different. Hard.
Lordship, I am to rely on judgment of one of the Supreme Court as regards what your Lordship should consider. Your Lordship is aware of, still I'm submitting, because on the last occasion, your Lordship made the query. Under 389, what factors your Lordship will take into account? And your Lordship regarding the extrajudicial confession, on the basis of extrajudicial confession, whether your Lordship may uphold the conviction. One print is very. Here, 2005, SC 1481. Oh, like this. Para 4, my lord. Here, 2005, SC 1481. Section 389 of the code deals, para 4. Section 389 of the code deals with suspension of execution of sentence pending the appeal and release of the appellant on bail. There's a distinction between bail and suspension of sentence. One of the essential ingredients of Section 389 is the requirement for the appellate court to record reasons in writing for ordering suspension of execution of the sentence or order appeal. If he is in confinement, the state court can direct that he be released on bail or on his own bond. The requirement of recording reasons in writing clearly indicates that there has to be careful consideration of the relevant aspects and order directing suspension of sentence and grant of bail. should not be passed as a matter of routine. The appellate court is duty bound to objectively assess the matter and to record reasons for the conclusion that the case warrants suspension of execution of sentence and grant of bail. In the instant case, the only factor which seems to have weighed with the High Court for directing suspension of sentence and grant of bail is the absence of allegation of misuse of liberty during the earlier period when the accused respondents were on bail. The mere fact that during trial they were granted bail and there was no allegation of misuse of liberty is really not of such much significance. The effect of bail granted during trial loses significance when on completion of trial, the accused persons have been found guilty. The mere fact that during the period when the accused persons were on bail, during the trial, there was a misuse of liberty does not per se warrant suspension of execution of sentence and grant of bail. What really was necessary to be considered by the High Court is whether reasons existed to suspend the execution of sentence and thereafter grant bail. The High Court doesn't seem to have kept the correct principle in law. So then para 8, in Vijay Kumar versus Narendra and others, and Ramji Prasad versus Ratan Kumar Jaiswal, it was held at this court that in cases involving conviction under section 302 IPC, it is only in exceptional cases that the benefit of suspension of sentence can be granted. The impugn order of the High Court doesn't meet the requirement in Vijay Kumar's case. It was held that in considering a prayer for bail in a case involving a serious offense like murder, punishable under section 302 IPC, the court should consider relevant factors like the nature of accusation made against the accused, the manner in which the crime is alleged to have been committed, the gravity of the offense, and the desirability of releasing the accused on bail after they have been convicted for committing the serious offense of murder. These aspects have not been considered by the High Court by passing service. Lordship, still I'll be making the submission since the evidences are in vernacular. The Lordship may kindly direct the registry to translate.
After giving attention to the records, on 2 dates.
With your Lordship, because
That kind
vernacular
of
portion,
submission-
your Lordship is not so much readable, my Lord.
That kind of submission is, I think, we have made efforts to read vernacular. Why you are finding difficult to read vernacular? We have been
Which
making efforts all the time. Whose evidence you find difficult to read?
Assamese persons, my Lord, they have translated it, no doubt.
Whose? Tell me. When we glance through it, so far, how many? 15.
15.
15.
Some are in English.
1 minute, total 15. Write it down. PW2 to PW11.
One is also in
No, please write it down.
PW2.
Out total 15.
Yes, PW2 to 11.
Entirely in English. I am looking at the original.
Lordship. Then I don't have to see.
Entirely in English.
Right.
PW1, CF is in English.
Yes, my Lord.
Only cross is in Assamese.
My lord.
PW 12,
Vernacular.
and 13 and 14. They are in Assamese. Okay.
Lordship.
PW 15 is in English. 313 is in English. So PW 12 to 14 and cross of PW 1. So 3.5.
Right.
3.5 are in Assamese.
Assamese.
And PW 12, he is SI, police. PW 13, he is
IO.
IO. PW 14 is also OC.
Yes.
So these are
Actual
IOs.
witnesses.
So what remains in Bhatingudla?
I'm making the prayer before this honorable
See,
chair.
this has to be reasonable. And if you want this cross of PW 1 to be read, I can read it out. It is legible.
It keeps pressure on the eyes, my lord, because of the handwriting. The manner it is
Handwriting, I
stated.
can't. So, except the cross of PW 1, all are in PW 2 to 9 or the PW 11. 11 is in English and plus 15. And other 3 are IOs. I would not record that submission as Assamese from. But it is not. What is the value of extrajudicial confession?
Lordship.
Weak.
I'll be relying on AR 1975, SC, 1975, 4 SC 241. AR 1975 SC 1320. Maghar Singh versus State of Punjab.
Heard Mr. H.I. Chaudhary, learned senior counsel, assisted by Mr. I.A. Chaudhary.
I.U. Chaudhary.
I.U. Chaudhary. Learned counsel for the applicant appellate. And M.S.B. Bhuya, learned senior counsel and additional public prosecutor for the opposite party state, assisted by M.S. M. Chakraborty, learned counsel. Also, the instant application under section 389(1), Code of Criminal Procedure 1973 is preferred seeking suspension of the execution of sentence passed against the applicant appellant and for his release on bail. Full stop. Para. The applicant as an appellant has preferred the accompanying criminal appeal, criminal appeal number 164/2023 against a judgment dated 28/2/2023 and an order on sentence dated 4/3/2023 passed by the Court of Learned Additional Sessions Judge Bilasipara, within bracket the trial court for short.
Sessions, please.
in Sessions case number 330 of 2014. Full stop. In the Sessions case number 330 of 2014, comma, two accused persons. One, Rohim Ali alias Rohimuddin Talukdar, within bracket A1. I, the applicant appellant. And two, Sattar Ali, A2, faced trial. During the course of the trial, the prosecution examined 15 witnesses. And exhibited 6 number of documents apart from a material exhibit. Full stop. At the end of the trial, comma, the learned trial court finding both the accused persons guilty of the offenses under section 30302 and section 201 IPC 302 IPC and section 201 IPC, read with section 34 IPC. Also, for the offense under section 302 IPC, comma, the accused persons have been convicted, have been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000 each, comma, with default stipulation for the offense under section 302/34 IPC. For the offense under section 201/34 IPC, comma, both the accused persons have been sentenced to undergo a rigorous imprisonment for 4 years and to pay a fine of rupees 5,000 each, comma, with default stipulations. Full stop. The sentences are ordered to run concurrently. Full stop. Para. Mr. Chaudhary, Learned Senior Counsel, appearing for the applicant appellant, has submitted that the applicant appellant has been convicted by the learned trial court, relying on an extrajudicial confession made by PW9 and a statement recorded of PW10 under section 164 CRBC.
10 is not 160.
Who's
PW 9 is 164.
Of period 9?
Yes, ma'am.
164-9.
But extrajudicial confession before 9 and 10.
No, no. Who extrajudicial? Father of a Sattar. Who is he?
10, 10.
10.
10.
Okay, now interchange kori lobo.
Umar Ali.
Omar. Omar.
A statement of PW.
Yeah.
Who's 164?
164 ke
PW
Dilwar.
9.
PW9. Dilwar.
Dilwar.
PW 9 recorded under section 164 CRPC. Who is Father Umar?
Yeah, that is PW 10.
And extrajudicial confession of PW 9. Full stop. Other than these two circumstances, comma, there was no other evidence to connect the appellant with the alleged homicidal death of the deceased. He has thus contended that he has contended that the statement of PW9 recorded under 164 CRPC cannot be taken into consideration due to violation of the mandatory provisions of section 164 CRPC, read with section 281 CRPC. Full stop. If such statement is left aside, only the extrajudicial confession of PW 10 would remain. Full stop. But the circumstances in which such extrajudicial confession, testimony of PW 9 regarding extrajudicial confession of the applicant. Then the same, for a line continue. He has further contended that the circumstances in which the alleged extrajudicial confession appeared to have been made by the appellant was doubtful, as other than PW 10, none had deposed to that effect. And PW 10 is the father of the other accused, A2, against whom sufficient incriminating materials were available. First, he has thus contended that the applicant, appeal preferred by the appellant, there is a fair chance of his acquittal. And in such view of the matter, the instant application for suspension of execution of the sentence deserves consideration. M.S. Bhuya, learned General Counsel and additional public prosecutor appearing for the state, has objected the instant application, submitting that the circumstances relied on by the learned trial court to return the finding of guilt against the appellant are sufficient. And the testimony of P.W. had added weight to the prosecution case. Full stop. M.S. Bhuya, Paralikhok, while Mr. Chaudhary has referred to the decision in Nikhil Chandra Mondal versus State of West Bengal. Criminal appeal number 2269 of 2010. Within bracket, Nikhil Chandra Mondal versus State of West Bengal, decided on 3/3/2023. To submit that extrajudicial confession is a weak piece of evidence. M.S. Bhuya has referred to the decisions in
Two decisions are made. AI 75 S 133.
Kishorilal versus Rupa and others. AIR 2005 SC 1481.
That is on the section 389 jurisdiction.
And which one?
For extrajudicial confession, I'll be relying on AI 1975 SC
And
1320.
Moghar Singh versus State of Punjab, 1975 4 SCC 234.
And one more.
One more. Objecting
2013.
to an application. Okay. Which one?
2013 3 SCC 322.
What was 13? কোনটো? ও এটু হেৰি কৰক এটু এই যে কি কয়
Oh, Lordship,
sorry,
then
sorry.
about
এটু যে নামটো
2009
হেৰি
11
কৰক
SCC.
Nikhil Chandra Mondal, State of West Bengal is 2023 6 SCC 605, huh? লিখিলা হ'ব বুজি পাইছে which one?
Oh.
কোনটো? It was done. Which one?
Lordship, I bought three, actually one wrongly I have given, it's a more stronger one, 2013, 3 SCC 322, R. Kuppuswamy versus State Representative Inspector of Police.
What does it say?
Lordship, if it is reliable, your Lordship may rely on. Para 8, that a truthful extrajudicial confession made voluntarily and without any inducement can be made a basis for recording a conviction against the person making the confession was not disputed.
Extrajudicial confession. Para. The FIR Trust Information Report was lodged by one Hasim Ali Mondal as the informant before the in-charge Salposa Police Outpost on 14/6/2012. Alleging inter alia that his niece was murdered by the two accused persons, A1 and A2, named in the FIR. Full stop. The FIR was registered as Sapor Police Station, case number 207/2012 for the offences under sections 376, 302, 201, 34 IPC. And thereafter, investigation was launched. Full stop. Admittedly, the case of the prosecution rested on circumstantial evidence, as there was no direct evidence. Full stop. As per the FIR, A2 used to acknowledge the father of the deceased as his adopted father-in-law.
Yes.
Full stop. The informant, Hasim Ali Mondal, is a brother of Ajahar, is a younger brother of Ajahar Ali Mondal.
Father of the deceased.
Who is the father of the deceased. Full stop. As per the person in the FIR, Ajahar Ali Mondal. No, on 7/6/2012, the deceased Asbanu Khatun, that is the daughter of Ajahar Ali Mondal, was taken along with her two brothers, by A2 to his house. Full stop. When Azhar Ali Mondal paid a visit to the house of A2 on 12/6/2012, he was informed by A2 that the disease was missing since the night of 11/6/2012. Full stop. It transpires that A2 on 13/6/2012 lodged a missing entry before the who is PW11? Before which police station? I need that only. Somebody deposed.
Yes.
Judgment page 27, my lord.
Page 66, he made
Ah.
GD entry number so
that-
and so on
Uh,
There are three of the judgment.
Salko outpost.
23A,
Yes.
before
Salkocha outpost.
Salkosa Police Outpost by General Diary Entry number 221.
Right.
Full stop. It has emerged from the evidence on record, evidence stroke materials on record, comma, as also mentioned in the affair, comma, that the dead body of the deceased found floating in a tributary of Brahmaputra at a place in front of a temple, Dudnath Mandir, in the morning hours of 14/6/2012. Correct. We'll come back. Post. As per the testimony of the autopsy doctor, comma, PW7, and the postmortem examination report, comma, the dead body was found in a decomposed state. Full stop. On perusal, comma, we find that there is no evidence, of materials on record to indicate that the deceased in the interregnum, comma, that is, comma, between the time when C went to the house of A2 and when the dead body of the deceased was found on 14/6/2012 was seen alive in the company of A1, that is the applicant appellant. Full stop. The deceased was found missing from the house of A2, where she was staying with the family members of A2 and her two younger brothers. Full stop. When we peruse the testimony of PW9, and the statement of PW9 recorded under section 164 CRPC. Comma, exhibited as EXT4, comma, we find that it is found that there is no signature of PW9 in EXC4 and PW9 had also deposed to that effect. Full stop. Such statement recorded under section 164 CRPC. Appears privacy in violation of the mandatory provision contained in subsection 4 of section 164, read with section 281. Within bracket 5, say 5. Within bracket 5, CRPC. Full stop. If the statement, if such statement, comma, EXT4 is to be excluded out of consideration, comma, the only circumstance which remains against the applicant appellant A1 is the extrajudicial confession alleged to have been made by him before PW 10, comma, who testified to the fact that such extrajudicial confession was made before villagers. Also, other than PW 10, the prosecution had not examined any other witness to corroborate such version of PW 10. Also, PW 10 is incidentally the father of A2, from whose house the disease went missing. Also, para. According to PW 10, comma, the alleged extrajudicial confession was made by the appellant, comma, A1 after he was apprehended by the villagers. Full stop. PW 10 had, comma, however, comma, deposed that he did not see the appellant A1 coming to the house of A1 to take away the disease from the house of A1. Full stop. In Moghor Singh Supra, it has been observed that if the court believes the witnesses before whom the confession is made and is satisfied that the confession was voluntary, then in such a case, conviction can be founded on such evidence alone. Provided the witness falls in the category of independent witness. Full stop. In Nikhil Chandra Mandal Supra, it has been held that an extrajudicial confession is a weak piece of evidence, and where an extrajudicial confession is surrounded by suspicious circumstances, its credibility becomes doubtful and it loses its importance. Full stop. It has been held as well settled that it is a rule of caution where the court would generally look for an independent, reliable corroboration before placing any reliance upon such extrajudicial confession. Full stop. The testimony of, the witness, as mentioned, as already mentioned here in a book, PW10 is the father of A1. And as such, prima facie, he does not appear to fall in the category of an independent witness. Full stop. Well, having regard to the above fact situation obtained in the case, we have the considered view that the applicant has made out a primary case for suspension of the execution of sentence passed against him
Sessions case number 330.
considering the settled principles in which settled principle as regards a case resting on circumstantial evidence. Full stop. Consequently, comma, the instant application seeking suspension of the execution of sentence passed against the applicant appellant and for his release on bail is allowed. Full stop. The applicant appellant is allowed to be released on bail on furnishing bail bond of rupees so and so 25,000 to the satisfaction of the learned trial.
Additional session plus Bilashi Court.
Trial court. With satisfaction. First of all. Do you believe? Do you believe?
Lordship, the observations made in the instant case
Ah.
will have in no way affect the variable.
We have clarified that the observations made hearing above are solely for the purpose of consideration of the application under section 389 CIPC. And the above observations shall not be constituted as observations as regards the merits of the accompanying appeal.
Reference case number may be mentioned.
Appeal. Heard Mr. H.R. Chaudhary, learned senior counsel assisted by I.U. Chaudhary, learned counsel for the appellant and M.S. B. Bhuya, learned senior counsel and additional public prosecutor for the respondent state assisted by Ms. M. Chakraborty, learned counsel. Full stop. As the records from the trial court have been received from our office to take steps for preparation of the paper. Full stop. Please the case after 4 days.
Lordship, as regards Sattar Ali, your lordship has allowed both the interlocutor. application.
Sattar Ali, anybody is pressing?
He is there.
Last in theory, I think.
Okay, let it be next week.
Lordship, he is there.
Is
Lordship.
there-
Okay. আগৰখিনি লিখা আছে না সব What explanation you have provided?
Your lordship, actually, I was.
Let us see 313.
Nothing.
Let us see 313. Where is your 313? আগৰখিনিতো আছে submission. খালি HR Chaudhary type. What is your name, please?
S. Paul, your lordship.
S.
Paul.
Paul. S. Paul লিখিব হা?
He has not annexed it. It is in the record, it is not in the
Let us see.
compilation.
Sattar. False.
Yes.
Now false becomes a circumstance. false in the face of overwhelming evidence and trend of cross-examination. You yourself had admitted by registering the missing link, or missing entry, that that lady went missing from your house. Now, thereafter, you are saying that false. In your 13, the missing entry you have made before the Halkosa, which has been exhibited, that you admitted that the lady went missing from your house. Then thereafter, everything was false. Now, the recent judgment authored by Justice Bela Trivedi, I think. False means that is a strong incriminating circumstance. If says false, so substance to table. Heard Mr. S. Paul, huh? Mr. S. Paul, learn it. Counsel for the appellant, huh? A1, A2 to assign, right? Likha assign, common asset. And BP. Mr. Paul, learned counsel for the applicant as applicant appellant, comma A2 has submitted that the prosecution has not been able to prove all the circumstances by cogent and credible evidence. And the scene of circumstance is not complete, pointing unerringly towards the applicant appellant A2 as the perpetrator of the crime. As the perpetrator of the crime. So stop. He has submitted that it is the applicant appellant A2 who had taken the initiative to search for the deceased, who went missing from his house. And as such, the investigating agency did not search it.
Yes, Your Lordship, I searched it.
Search it. The applicant appellant. So it was only by an order passed by the learned trial court under section 319 CRPC, the applicant appellant was made to face the charges in the trial. First, para MS Priyan so and so has contended that it was not denied by the applicant appellant. No, the applicant appellant was not successful to disprove that the deceased went missing from his house and the missing entry, that is the Nell Diary entry number 221, lodged on 13/6/2000. Sorry. 13/6.
2012. Exhibit.
221.
Exhibit A.
Has substantiated the said fact. Full stop. In such backdrop, comma, the applicant appellant A2 owed an explanation as regards such circumstance adverse to him when he was examined under section 313 CRPC. But when the applicant appellant A2 was examined, were such circumstances, comma, he simply denied that circumstance as false. Full stop. Such denial of circumstances false by the applicant appellant has completed the chain of circumstances in the backdrop of last seen together theory. This is it. You have a session. তাৰপিছত এই ঘৰ যোৱা এফাৰ ষ্টৰিটো লিখি দিব, এফাৰ ষ্টৰিটো ৰিপিট কৰি দিব। আগৰ কেছটোত হয়তো ৰিপিট কৰি দিব, ডিকম্প'জ বডি চডিখিনি ৰিপিট কৰি দিব। From the materials on record, it has emerged that about 4/5 days prior to 14/6/2012, the deceased was taken by the appellant A2 from her house, and since then, the deceased was staying in the house of the applicant appellant A2. It was from the house of the applicant appellant A2 the deceased went missing. Postmortem examination report. Report আছে বা? report আছে নেকি? Exhibit চাব লাগিব তেনেহলে।
Page 41 your lordship.
Page 41 কিবা লিখিছে নেকি approximate time of date?
Yes, it's written there.
Approximate time of
36
date.
hours. 36 hours.
As per the postmortem examination report. EXT.
Evidence of PW7, it is come up.
Okay. As per the testimony of the autopsy doctor. PW7.
Page 16, your lordship. Postmortem was done on 15/6/2012.
The postmortem examination was done on 15/6, was performed on 15/6/2012. And was done on full stop. PW 7 opined that the postmortem was conducted after about 36 hours from the date of the deceased. Full stop. Thus, the date of the deceased would be relatable to (12/6/2012) or prior to that. Full stop. It has emerged that the father of the deceased paid a visit to the house of the applicant appellant on 12/6/2012. And only during that visit, it was disclosed to father of the so-and-so, PW 5. And it was only during such visit, it was disclosed to PW 5 by the appellant A2 that the disease was missing from his house from 1 day prior to 12/6/2012. Full stop. But the appellant had chosen to offer or chosen to deny such circumstance as a false one during his examination under section 313, which itself is a strong circumstance against him. In the above fact situation obtaining in the case, we are of the considered view that the application, the instant application under section 389 CRPC of the appellant is not merited and is deserved to be rejected. Full stop. It is accordingly ordered. Same in the appeal, same order. Agotor is the appeal, same order. Sequence to milai dibo khale. Common facts. কি ধর্ম শত্রুপাতি কি করে আছে
Item number 12.
Maybe, Your Lordship. Main case.
Yes, Mr. Azad.
Notice was issued, my lord, in main case, my lord.
Huh?
Notice was issued, my lord. Accordingly, I have-
Answer notice.
accordingly, I have taken step, but
Let us
Service-
put it to the Lojima Code 302.
my lord, my lord.
Then they will come up with a report that notice is served. Then after that, we can proceed.
My lord.
Okay.
And my lord, in IA, my lord, notice has not been issued, my lord.
You and I.
IA, my lord.
Okay.
344, my lord.
Heard Mr. A.K. Azad, learned counsel for the appellant. Epilogue, huh? And MS A. Begum, learned additional public prosecutor for the respondent number 1, state of Assam. So stop as per office notes. Dated 16/8/2024, neither answer notice nor ID card has been received back after service. Let the case be placed before the Lojima Court to ascertain the status of service of notice upon the respondent number 2, sent by a registered post with AD as well as by post. Place the case after 2 weeks in I. Yes, how much time?
3 weeks, Lord.
Then 3 weeks go by 2. Heard Mr. A.K. Azad, learned counsel for the appellant, and MS A. Begum, learned additional public prosecutor for the opposite party number 1, state of Assam, the recent application under section 389 CFPC, seeking suspension of the execution of sentence passed against the applicant appellant and for his release on bail, post of issue notice returnable in 3 weeks. MS Begum, who has received a copy of the application. Huh?
I copy will not.
Okay.
receive.
MS Mr. Azad, learned counsel for the applicant appellant, shall furnish a copy of the application by today
No,
to MS Begum during the course of the day. Post of learned the objection by the state to the instant application is to be filed within a period of on or before the returnable date.
Item 13.
May I please, Your Lordship?
Yes, you're right, you're right.
My lord, I'm basically today I'm coming up for pressing of the IA, my lord. Because the appellate we admitted, LCA was called for, and the learned edition public prosecutor has filed the objection also, my lord.
Now, I'll share you. Yes.
Yeah, my lord. In this case, my lord, it's a case of last seen together, my lord. So there were 2 accused appellants. We are representing one, sorry, my lord, 2 accused faced the trial, joint trial. And out of that, both of them were convicted, my lord.
What is the judgment
My lord, judgment starts from page 430. One page.
in the appeal?
Yes, my lord. In the appeal, we have nowadays annexed it with the IA also. It
Is-
starts
in
with
the
relevant.
IA
to page
also?
70.
IA?
Yeah. IA 17, my lord.
Sessions case. Your applicant is
My lord, I am appearing for Jahrul Ali, my
A2.
lord.
A2.
A2, my lord.
Hmm.
Date কিমান আছে? আজি কিমান হ'ল?
The whole case based upon circumstance evidence, my lord. And the only one single circumstance has been taken into account, that they went together. And thereafter, there was no information. Subsequently, next night, on the morning, my lord, the dead body was recovered.
When the FIR was lost,
My
where is
lord,
the
FIR was
FIR?
lodged on 28/3/20,
Where is the FIR?
29/3.
Where is the FIR?
Yes, my FIR is in the law court, my lord, record. my lord.
Records.
Yes.
I think it would have been better than it just because we are two. Had the paper book been ready, it would have been better.
That's there.
We are two, difficult to look at the same time in the same.
My lord, we have one copy. my lord.
Paper book নহলে দিগদাৰী হয়। To look from records, robo. Roto. Itu authorized হচ্ছে। Itu authorized হচ্ছে। Itu authorized হওক প্ৰথমে। Itu authorized হওক। লাগতিয়াল যিটো নালাগে মই এইবোৰ চাই থাকিব নোৱাৰো। Itu authorized। Itu authorized। দেখা না 29
29. That was on the
ৰাতি 10 বজাত
28 about
আমাৰ
10
ঘৰলৈ
PM,
কিবা কথা আছে মোৰ স্বামীয়ে বাহিৰলৈ মাতি নিয়ে জানি বুলি কয় ৰফিকা ৰফিকে জানি বুলি কয় কোন নাজানে 8, 10, 29 morning 9টা বজাত জানো কি হবে এই exhibit খিনি বুজি পাইছে exhibit খিনি পাইছে আছে আপোনাৰ কাছে Do you copy of testimonies?
Yes, evidence, my deposition.
Okay, I see. Okay. And I'll look from the original.
I'll give
My
for
sister-
the
my
lady
sister
lord.
has.
No, we have extra copy. I'll give.
No, it's okay. I'll look from the original record.
Instead of putting.
Okay, what is the evidence regarding that recovery of the corpse?
Well, the recovery of the corpse was that somebody saw it in the morning.
When?
Next day morning, my lord. On 29.
Date.
Yes, 29.
Date.
Yes, 29.
FIR did
20
not say so.
No, because that time they were not aware. Only living they were aware.
Who has testified about that?
My lord, that thing during investigation it came up, my lord.
Huh? No, who
Subsequently,
has
everybody
testified?
started saying, my
No,
lord.
who has testified?
But actually, the issue before your lordship is that which I'll also raise, my lord, that the person in whose pond the dead body was found was never examined during the investigation and also probably during the trial, my lord.
When the dead body was found,
Next day, 29.
what is the evidence there?
Yes, that evidence is coming from the mouth of PW1, the Reshma Bibi, my lord. I am the informant of this case. FIR, exhibit P1.
Okay, on 33/2020, the dead body of my husband was found in a pond at Murmela. Okay. Sufficient to cause death. Sufficient. Records. Injury marker.
So, my lord, now the facts remain, my lord, that the person from whose the pond was, the dead body was recovered, my lord, has not been examined in the case, my lord, who is a very much vital witness, who could have unfold as to how he died, my lord. So
That
nothing-
is a different thing, but somebody PW8,
Yes.
PW9, and you have
It is
decided not to.
No, Nasibur
cross.
Rahman, the
Finding
village,
of dead body is there.
my lord.
Finding of dead body
Yes.
floating on a pond has been deposed to by PW8 and
That is what
PW9.
saying. Now,
And you have chosen not to cross-examine on that point.
no,
That is the appreciation of evidence at a
that
matter.
is one aspect of looking into things. The other aspect is first the core case of the prosecution has to be established. If request, then only I cross-examine him, my lord.
Let us see.
That is the golden principle of law. Otherwise, why should I cross-examine if there is no necessity also, my lord?
Good enough.
Now, my lord, which I like to throw upon your lordship is the fact that whether the medical report says as to how he died, my lord. That is important, my lord, that your lordship will come through the evidence of PW7, my lord. Shall I take your lordship to be evidence?
28 at 10
Yes, my lord. They went out together, my lord.
went out together.
Right, my lord.
Both A1, A2 and the disease.
Absolutely. Right. After dinner, they went out together and he didn't come back. So after 8-9 hours, the wife was,
After that morning,
yes,
went to A1 and thereafter A2.
you might, correct.
And on that next day morning, the
Thirty.
body was found floating
Floating in the pond.
with injuries on his person, and those injuries were found to be sufficient to cause death in the ordinary course of nature. And according to autopsy doctor, it was a homicidal death.
No, also accidental.
I will see to that.
That's why I was,
We are not here. We are only on 389.
that's there, my lord, but
So far,
I'll try to make out a case, my lord. What are the
so
legal
far,
position?
the above injuries are sufficient to cause death of
That
a
is not a
person.
correct proposition because your lordship will have now just.
No, we are not testing in detail.
No, not in detail.
Let us
my
be clear also.
Whether prima facie, this is acceptable evidence or not, my lord. Because in the cross, he clearly says how.
Death was due to the homicidal injury and drowning.
Yes, how can he say that drowning, my lord? Because on the pond, I have clarified it if your lordship.
We are in 389, Mr. Kamar. At least I am sure about the parameters.
Then I have got nothing to say.
We are not dissect right now.
My duty is to point out your lordship
But
will accept.
what are
it
the
or
strong
reject it.
circumstances which is not?
That is the only circumstance that we went together and the person did not come alive, he died in between. Now, when we parted, when we came, my lord, all these are not there. Only thing is there, my lord, the doctor injuries that has given, if your
Have
lordship
you
verify it, these are all minor injuries, my lord. Just because the doctor says doesn't become the gospel truth under section
No, no.
45 of the Evidence Act. Your lordship will
These are
look into it.
all appreciation of evidence.
No, right now, prima facie, I'm trying to show my
Prima facie.
where the judgment went wrong, my lord.
Okay. Where?
Yes, my lord. But
Okay, we'll come back.
yes, I'm just reading.
Will be my. Okay, my sister will be sitting in single bench at 2 to deliver some judgment. So 2:05 or 2:10.
Well, in the morning session, I was in the evidence of the doctor, my lord, PW7, my lord.
PW.
7, my lord. The opinion that he has given is like this, my lord. The person was assaulted on the face and from the back and put in a pond. That was due to both homicidal injury and drowning. This is the opinion and his evidence, my lord. It was only the court asked, my lord, whether the above injuries are sufficient to cause death of a person in ordinary course. Then the reply came, yes, the above injuries are sufficient to cause death of the person in ordinary course. But my respectful submission is that which are those injuries? Because these are mere simple injuries, my lord. Then when he was cross-examined, my lord, he categorically stated, in my opinion, I have mentioned pond on my assumption. So it was only on assumption and surmise that he has opined, my lord. Otherwise, how will you know that it was drowning in the pond or in a river? Because the time gap in this case of departing, my lord, is a huge time gap, my lord. Till the finding of the dead body, my lord. And no enmity or any other thing has also surfaced, circumstance, except one circumstance, that they were last seen going out at 10 PM from the house of the deceased, my lord, together, my lord.
Where is the postmortem examination?
Postmortem is there, my lord. I have given that punch also it again. Certified copy, we have it, we can share it. Yes.
No, it's okay.
Your lordship bought it? No. Because ultimately, my lord, the stomach, the abdomen and lungs all filled with water, my lord. এটা কি manipulate idea? Manipulate idea, market beta money. Into you could get to 30, 40 hours before. But it is start by 28 তারিখে 10টা বাজার পর start হবে। এটা তো দেখতে হবে না জানি একদম কিন্তু ডক্টর একটু ওপিনিয়ন দিচ্ছে আপনি এটা কেটে কেটে করুন করে দিচ্ছি হ্যাঁ থার্ডলি থেকে যাবো থার্ডলি থেকে যাবো
What is the IO?
IO is a PW 13 minor. There are two IOs. One is 11 and 13. PW 11 is one of the IO minor, Jyotin Chandra Das. Shall I read, madam?
PW11.
I know the informant Reshma Bibi, I also know.
He's headman.
Yes.
He's
PW
village
11.
headman.
PW 11.
It's a village headman.
Village headman.
Yes. 13 minor. Sorry. Only the return IO decision. That's the IO minor. Interest of amount also.
Yes. Anything more? Anything?
Well, just adding 2 lines, my lord, I would like to submit, my lord. The medical report is not complete, my lord, to show that the injuries sustained are sufficient to cause the death in ordinary course, because all the injuries were superficial or sharp cutting weapon, nothing has been stated, my lord. Only the injuries were found. So what were those injuries, my lord?
PW seven
Seven.
should have been cross-examined vigorously,
Yes, that's true, my lord. But
vigorously.
yes,
Huh?
there was scope, my lord.
Court has the power under one sixty-five
absolutely.
to ask a question.
No, there's no doubt.
Court has asked a question.
Yes.
He answered. Thereafter, you could
That-
have cross-examined him
That
and
answer-
should
That's
have.
true, my lord. That answer is not giving the full picture, my lord. That is my
That
reference.
is a medical science which is
No, why I say so,
to
my
be.
lord. After going through the injuries, it ought to have said that these injuries were caused by sharp weapon or by blunt.
But what did you do in your cross-examination?
My view is that, my lord, that he has stated directly that it was he died due to the falling in the pond, which cannot be because he is not aware. Actually,
No, what did you do in your cross-examination?
That is there, my lord. I cannot improve it. What is on record, I will submit there only.
After categorically opining by the autopsy doctor in this manner, there should have been vigorous cross-examination of PW 7 vis-a-vis the injury sustained
No,
by
my
the
lord.
disease.
Sometimes cross may not be
Otherwise, timeline is matching.
that they
30 to 40 hours.
40
If
hours.
we
missing is
relate back
missing is
40
not
hours, then it is exactly 10 p.m. on 28/3/2020.
Right.
And he doesn't know what is the case, but he has clearly said 30-40 hours before
But in
postmortem.
criminal jurisprudence,
Postmortem was done at 1 p.m. on 30/3/2020.
right, ma'am.
If we
No, I'm
take
that's why I'm
back
not disputing
40
that facts.
hours back, then it is exactly 28/3/2020, 10 p.m.
10 p.m.
Then in the next 10 hours, it had happened. The lady went to your house at 8 o'clock in the morning.
morning. That is all there, my lord. What I am trying to impress upon your lordship is that, my lord, that the injuries has not been described. What are those injuries which
That
were
will be a matter of
or not?
full-scale hearing.
My lord, I'm just trying to impress upon your lordship of the
That
other
will be a
judgments
matter of
also.
full-scale hearing,
My
Mr.
lord,
Kamar.
there are judicial pronouncement, my lord, that there must be some enmity if they have to kill it. Because only fact is that, my lord,
Have
that
you
parting time.
read the recent judgment of the Honorable Supreme Court, Wazir Khan?
Wali Khan, I have not read. I have read other 2-3.
Wazir Khan. And
Rafiq Hussain, there is no- one hour.
exactly your situation.
Yes, ma'am.
Though there was a 364 abduction, here it is not abduction,
No, no.
not forceful, but there one judgment was referred,
That is,
and that
if I show your
Supreme Court
lordship,
said that when this situation, this exactly your situation, then High Court only convicted them under 364,
for
not
kidnapping.
a trial court and High Court. Supreme Court, no way,
Got it, ma'am?
returned
No.
finding of guilt under 302.
If there
So
are
you
few-
have to look into that.
No, no, your lordship will now look into the judgment which is in our favor also. So I will be relying on the favorable judgments, my lord. So I found 2 from the Supreme Court, which says, Vikram R. Srinivasan. Because judgment in both the ways, my lord. Now, how it is applicable in the case, because all criminal cases are decided on the facts. Only
Let the
precedent the
paper book be
principle.
ready.
Because the judgment that was relied by the trial court is one Rafiq Hussain that doesn't covers our case itself. That there was kidnapping, my lord. But
No,
here
kidnapping
it
cannot be
madam.
kidnapping.
Here I am
You have been
relying on two
convicted for
judgments,
kidnapping
my lord.
also.
one in 2014 and one is in.
You have been
2023, my lord.
convicted for kidnapping also?
My lord. No,
Huh? Oh, 365.
yes,
365.
there cannot be kidnapping, my lord,
Maybe you have a case, but so far.
because it.
You have
was
been
all
convicted, had it only been 365, yes. But you have been convicted for 302 also,
Yes,
in aid of 3.
because
34.
365 cannot come into the play, my lord.
Hmm.
That's what I'm finding the defect, my lord. Only I'm.
That is what my tentative view. Had you been convicted only under 365, yes, you would have been a better case for 389. But not 3. When 302 is involved, I don't think you have a primacy case for 389 benefit. Hard.
Just, your lordship was asking some judgments, my lord. I'm relying on one 2023 Zero Supreme SC 836, my lord. R. Srinivasan appellant, my lord.
Do you have a
the-
copy?
I give it.
Quote a second. This is 389 or
No,
full scale hearing?
Hearing, my lord,
Ah,
but the
full-scale hearing.
proposition, my lord, last seen together. Because
Which
the
one?
leading case in favor of the accused is Kanhaiya Lal and against is Bodhraj.
Which one?
I was
Paragraph?
just saying what my knowledge.
Paragraph?
Yes, I'm relying on para 15, my lord. Page 5.
15.
The burden of the accused therefore kicks in only when the last in theory is established. In the instant case that the cost of reputation debt itself is in doubt, this is borne out from the subsequent decision of this court which we would like to advert, Kanhaiya Lal versus State of Rajasthan 2014, wherein it was noted. The circumstance of last seen together does not by itself necessarily lead to the inference that it was the accused who committed the crime. There must be something more establishing connectivity between the accused and the crime. Mere non-explanation on the part of the appellant in our considered opinion by itself cannot lead to the proof of guilt against the accused appellant. Nizam versus State of Rajasthan 2016, 1 SCC 550. The relevant discussion contained in paragraph 16 to 18 after noticing Kashiram. In the light of the above, it is to be seen whether the facts and circumstances of this case, the courts below were right in invoking the last century. From the evidence discussed above, this is Manoj allegedly left in the truck of DL1G as such. The body of the deceased Manoj was recovered on 26. The prosecution has contended that the accused person was last seen with the deceased, but the accused has not offered any plausible, cogent explanation as to what happened to Manoj. Be it noted that only in the prosecution has succeeded in proving the facts by definite evidence that the deceased was last seen alive in the company of the accused. A reasonable inference could be drawn against the accused, and then only honors can be shifted on the accused under 106 of the Evidence Act. So just cutting short, my lord, para 18. In view of the time gap between Manoj left in the truck and recovery of body and also the place and the circumstances in which the body was recovered, possibility of the other intervening cannot be ruled out. In the absence of definite evidence that the appellant and the deceased were last seen together when the time gap is long, it would be dangerous to come to the conclusion that the appellants are responsible for the murder of Manoj and are guilty of committing under murder of Manoj. Whether time gap is long would be unsafe to base conviction on the last seen theory. It is safer to look for corroboration for other circumstances and evidence adduced by the prosecution. From the facts and evidence, we find no other corroborative piece of evidence corroborating the last seen theory. So in our case also, there is no corroboration save and except that going together out from the house. Because it was 40 hours gap is there. Since the
Time gap between dates. Between dates.
33 at the most, we have calculated.
Between the last seen alive
And
and
before
the
postmortem.
date
Yes.
is
Your
From
lordship also
10
said 40
PM.
hours. Yes.
From 10 PM night of 28/3/2020 to 8 AM morning of 29/3/2020. That is night.
That was only saying that when we parted,
Hmm.
one is saying that he was with him, other co-accused was saying he was with him. So that time gap of 40, your lordship has come it from
Not
your lordship mouth
40,
itself.
not 40, Mr. Kamar, it
40.
is 10.
But if we calculated
For
dead body floating time, it was
floating time,
33 hours.
30 to 40 hours. That.
That is from the postmortem. But from seeing the dead body floating on the pond,
Dead
on the
body
pond.
in a place which is not.
it's a house pond, my lord. He might have fallen.
We know the villages, how
Yeah,
ponds
so
are
We
located.
also know, my lord. We
Ponds
all
are
know.
not located in the lawn. Ponds are located in the backside.
Injuries in the backside.
We
That's what
have
I'm
in our
saying,
village,
backside
we know where the
injury may be
pond,
caused by fall also.
anyway,
By throwing
not
somebody,
a case for.
backside injury may be occurred. by
Because he
falling
might,
injury.
because all his organs, if your lordship will see, they were full of waters, my lord. It was not that somebody was
So
pumping.
sometime already. Whether there was intention or not, that is a different thing.
No, first thing-
28, but the injuries might be prior to
Yes.
throwing the body or person in the pond.
No, it
Maybe,
is because the doctor said. it is
maybe
body
the
surface.
injury preceded drowning.
Maybe, man. Your
Injury
lordship
might
is
have
right,
been,
man.
might have preceded drowning in normal course.
Because
Drowning cannot precede the injuries.
no, sometimes it happens, my
See,
lord, when a
mister,
person gets drowned,
somebody drowned.
he may hit the bottom of the
Oh,
river.
no,
or-
in not many parts. Not in many parts. It is
I'm
quite
saying
out of
medical
common sense.
jurisprudence, my lord.
Somebody in a pond
Yes.
and he will be, suppose, drowned on his own. Can it be possible to have injuries in all those parts?
No, back-
Over
backside-
face,
Back, back.
overhead,
Yes,
backside of the body,
Head is
right
possible.
upper extremity.
my lord.
He will go on twisting and getting injured himself.
My lord, when
That
he-
is quite
When he
out of
fails-
common sense, Mr.
No, no.
Kamar.
Common sense sometimes defies my lord science, my lord.
Defies-
That I am trying to
But
say.
that is not rocket science.
No, definitely
We
not.
can understand at
But
least.
that is medical science, my
It
lord.
is the drowning did not precede injuries. Injuries preceded drowning.
That is not come in evidence.
Judge, that is what said. Judge is not to preside over only in case of conviction. It is also to be heard.
I leave it to you, lord.
Mr. J. Kamar, learned senior counsel, assisted by R. K. Sharma, learned counsel for the applicant appellant, and Ms. A. Begum, learned additional public prosecutor for the opposite party, number one opposite party, State was the instant interlocutory application under section 389(1) of Code of Criminal Procedure 1973 is preferred by the appellant seeking suspension of the execution of sentence passed against him and for his release on bail, full stop. Para, the applicant as the appellant has preferred the connected accompanying criminal appeal number 104/2024 against a judgment, an order dated 7/3/2024 passed by the court of Learned Session Judge Baksa at Musalpur. Judgment order dated 7/3/2024. In Sessions case number 82 of 2022. Full stop. In the trial of Sessions case number 82 of 2022, two accused persons, that is, 1, Roman 1, Mohammad Rafiq Ali, within bracket A1, and 2, Mohammad Zaherul Ali, within bracket A2, that is the applicant appellant, faced charges under sections
365,
365
34, and 30230.
stroke 34 IPC and section 302 stroke 34 IPC. Full stop. During the trial, the prosecution examined one witness, Asian witness, 13 number of witnesses, and exhibited 8 number of documents to bring home the charges against the 2 accused persons. Full stop. At the end of the trial, the learned trial court finding both the accused persons guilty for the offenses under section 365 stroke 34 APC and section 302 stroke 34 APC. Have sentenced them to undergo rigorous imprisonment for life and to pay a fine of rupees 2,000, with default clause for the offense under section 302 34 IPC. Full stop. For the offense under section 365 stroke 34 IPC, both the accused persons have been sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 2,000 each, with default stipulation. Full stop. The accompanying criminal bill, criminal bill number so and so has already been admitted for hearing on 9/4/2024. Mr. Kamar, learned senior counsel, appearing for the applicant appellant, that is Zaherul Ali A2, has contended that the learned trial court has erred in applying the last in theory, together theory, to return the finding of guilt against the accused persons, more particularly, against the applicant appellant. Full stop. It is his contention that the prosecution had failed to establish all the circumstances by closing and credible evidence, and as a result, there were many missing links in the chain, and as such, the conviction of the applicant appellant is completely unjustified. Full stop. He has further contended that the injuries allegedly sustained by the disease were not such injuries which would result in death of a person in the ordinary course of nature, right? Full stop. Mr. Kamar has also referred to the decision to a decision in R. Srinivasa versus State of Kerala, reported in
Two thousand twenty-three.
2023 INSC 803. Let us cite neutral citation.
Yes, my lord.
To contend that the last seen together theory is not applicable in the case in hand. More particularly, when there is failure on the part of the prosecution to establish the motive, to bring in the rule of evidence contained in section 106 of the Evidence Act into operation. That is your case?
Right.
First of Ms. A. Begum, Ms. Begum, learned additional public prosecutor, opposing the application, has contended that the autopsy doctor, PW7, in his testimony, had clearly opined that the injuries sustained by the disease were sufficient to cause death of a person in the ordinary course. Post up. Though the autopsy doctor had opined that the cause of death was due to both homicidal injuries and drowning, the injuries more than one, were definitely sustained by the disease prior to drowning. Post up. Ms. Begum has further contended that on 28/3/2020, the disease was last seen alive together in the company of both the accused persons, A1 and A2. And in such situation, the accused persons owed an explanation under section 106 of the Evidence Act. But the accused persons, including the applicant appellant A2, did not offer any plausible explanation, much less plausible one, in their examination under section 313 CRPC, or nor by way of any suggestions, even not by way of any suggestions during cross-examination of the prosecution witnesses. We have considered the submissions of the learned counsel for the parties, and I have also looked at the evidence took materials from the court for the purpose of consideration of this application, preferred under section 389 CRPC. Postal. For consideration of an application as section 389 CIPC. Comma, the appellate court is not supposed to reappreciate the evidence and to look for few lacunas or loopholes here or there in the case of the prosecution. First of while undertaking the exercise, comma, the appellate court if the appellate court finds that there is something palpable or glaring, then only such an application should be considered favorably. Full stop. The power exercisable under section 389 is different from an application either under section 437 or under section 439 of the code, comma, pending trial. For the reason that the presumption of innocence, quote unquote, and bail is the rule and jail is the exception may not be available to the appellant who has suffered a conviction. From the evidence, prosecution evidence, comma, it has emerged that it has prima facie emerged that at around 9 p.m. on 28/3/2020, comma, A1 came to the house of the deceased and had dinner with the family of the deceased. Full stop. The said fact was also admitted by A1 when he was examined under section 313 CRPC. Full stop. It is a case of the prosecution that on the same night at about 10 p.m., both the accused persons, A1 and A2, again came to the house of the deceased and called the deceased on the pretext that they had to discuss something with the deceased. And on their such call, comma, the accused or the deceased went out with the two accused persons. And since thereafter, comma, the deceased was found missing. It is the further case of the prosecution that on the next morning, on the morning of the following day, in the morning of the following, on the following day, the wife of the deceased, comma, P1, went to the house, says, of the accused persons, two accused persons, to know whereabout of her husband as he did not return home till that time. When found the answers, when the answers of the two accused persons were found incoherent in nature, comma, the FIR came to be lodged. By the wife of the deceased. In a, at around 5 p.m. on 29/3/2020. Post of. It was on in the early morning hours on 30/3/2020. The dead body of the deceased was found floating in a pond located in the same village,
No, but different one.
located in a nearby village.
Nearby. Mullabari. Murmela.
Located in a nearby place, in a private pond, located in a nearby village. Full stop. After recovery of the dead body, postmortem examination was performed at Dr. R. Boro Civil Hospital, Musalpur. At about 1 p.m. on 30/3/2020 by the medical and health officer posted there, PW 7. Full stop. As per the testimony of PW 7, there were injury marks over head, back of head, backside of body, and right upper extremity within bracket, including cut marks. Full stop. According to the autopsy doctor, the death was due to both homicidal injuries and drowning. And approximate time of death was 30-40 hours before postmortem. The autopsy doctor further opined that the injuries sustained by the disease were sufficient to cause death of a person in the ordinary course of nature. If the time period mentioned, time of death mentioned by the autopsy doctor is accepted, then the time of death of the deceased would fall between 10 p.m. on 28/3/2020 and 8 a.m. on 29/3/2020. Full stop. In the submission, the submission as to whether the injuries sustained by the deceased were sufficient to cause death in the ordinary course of nature is a matter which can be examined in the course of the detailed hearing. Full stop. At this stage, such contention need not be gone into. Full stop. Para. From the materials on record, as discussed above, we are of the considered view that the appellant has not been able to made out a prima facie case for extension of the benefit under section 389 1 CRPC at this stage. Post finding and the instant application in our considered view is not merited. To stop accordingly, the instant application stands dismissed. Full stop. Observation made hearing again liquidable only for the purpose of hearing, not for a competent hearing. So we kept it for that.
My lord, as your lordship, only prayer, my lord, in the appeal, can the paper?
Had Mr. J. Kamar and a senior counsel assisted by so and so for the appellant. And you are appealing for one only.
Yes, my lord.
Any connected
Yeah,
appeal?
it is there, my lord.
It is there.
It is.
Can you mention?
That I don't know,
Have you
my lord.
any idea?
But no, I have taken view, my lord. Mr. T.J. Mohanto appears. So the connected appeal may be directed to be.
No, that will be difficult. MS A. Begum, additional public prosecutor for the respondent state.
It will
So
be
as
connected,
the
my lord. Because it is
records-
one act here, my
records from the trial court have been received, office to take steps for preparation of the paper book, is the case after 4 weeks.
4 weeks. Much of it.
Mr. Kamar, you look into this judgment,
But I'll definitely look.
2008 SCC 382,
2000?
8 SCC 382, which has been referred to by in Wazir Khan. Exactly your situation.
Well, we'll come to tell my lord at the time of hearing.
Supreme Court reversed acquittal of under 302. Going out together,
Definitely.
then you owe an explanation.
Actually, as
And
I
this
can
is what the
understand, my lord,
observation is.
the golden principle of lasting together is the parting time, my lord. Going together, everybody can say, but when you part is the special knowledge of the accused person.
Right. When it is proved to the satisfaction of the court that X was abducted but had taken by the accused and they took him out of the area.
Eh,
The accused alone knew what happened to him until he was with them. At least when you parted company, there should have been some evidence. If he was found murdered within a short time after the abduction, the permitted reasoning process would enable the court to draw the presumption that the accused have murdered him. Such inference can be disrupted if the accused would tell the court what else happened to X, at least until he was in their custody. With that reasoning, reversal was done.
There's the right.
There are many cases.
Maybe.
Many cases. Some for to your benefit, some.
Judgments are always there.
But that is a
But the
case
golden
for
principle remains.
detailed hearing.
But the golden principles remain. Here in my case, that medical evidence will come in favor of me.
That is why I have kept it open.
Yes, I got it, madam. Much obliged.
Item number 14,
Oh, এই জাজমেন্ট এটা বলেই বলি জাজমেন্ট এটা বলেই বলি জাজমেন্ট এটা কি আছিল মই রিলাই কৰা নাই কেমন রিলাই নকৰো অ এই জাজমেন্টৰ ৰিঅ্যাকচন জাজমেন্টটো কোন হ'ল না জাজমেন্ট কিটা মিছ কৰিলো নেকি এইটোৱে আৰু কোনটো আছিল? হা Hmm. It is uh, it has been observed in R. Srinivasa Supra that in the absence of definite evidence that the appellants and the deceased were last seen together, and when the time gap is long, it would be dangerous to come to the conclusion that the appellants are responsible for the murder of the deceased and are guilty of committing murder of the deceased. Full stop. Where the time gap is long, it would be unsafe to base the conviction on the last seen theory. Full stop. Keeping when in that context, the materials emerging from records of the instant case is looked at, it emerges that the time gap here appears to be about 10 hours, as indicated above. Full stop. Whether such time gap is a prolonged one to leave out the theory of last seen together is a matter which can be considered at the stage of detailed hearing. The decision here.
Item 14,
আপুনি লৈছিলতো? Yes, yes, madam.
As per office note dated 16/8/2024,
Hmm.
Lordship, the service appointed respondent number 2 has not.
Offense under 302. Hard MS.
Lordship, kindly may allow us to take fresh steps, Lordship.
No, we'll put it to Logiba court to trace out. If they say that
Yes.
service is affected, no, not required trace steps. Hard MS
And Dekaraja, Lordship.
and Dekaraja learned counsel for the main appeal to the Paskur. Accused appellants and MS A. Begum learned additional public prosecutor for the respondent number 1, state of Assam. Post. Madam, you have not taken steps in the main appeal.
Lordship, we will take steps, Lordship.
That is the report. You take steps in the main appeal. Okay. You want it. MS Dekaraja learned counsel for the appellants. I have sought for 3 days time to take steps for service of notice upon the respondent number 2 in terms of the order dated 1/5/2024. Post of lays the case after 3 weeks.
Much obliged.
item 15,
regular body main appeal.
No, this is for bail, my lord, suspension of sentence.
Oh. Yes,
The
yes, objection
PPS file an affidavit, my lord, objection.
today. You all have the privilege to look into the objection, but we don't have that privilege. It is not in the record. Mr. Sen has filed it late.
PP has already filed a minor objection.
No, his objection is not on record.
Yes.
Okay, let it be next week then.
Well, the date may be provided.
দি দিব date. Mr. Borua, B. Borua, আগৰ নামকেইটা লিখি দিব। আগৰ নামকেইটা লিখি দিব, আগৰ order, আগৰ যিকেইটা নাম আছে, সেইকেইটা লিখি দিব, repeat কৰিব। Mr. Sen has submitted that he has filed an objection. Has submitted that an objection on behalf of the respondent number 2 has been filed today. As the objection of the respondent number 2 that's informant, stated to have been filed, is not with the case record, list this case on
2008.
with the said objection of the respondent number 2 on record,
30, my lord, I have some difficulty. 20, can it be on 29, my lord? I will be okay.
not 29.
First week of September, any date.
Then on 5th, my lord, 5th. 5th of September, my lord.
6th.
6th. Publish.
Item 16.
এই delay continuation আছে না? আপনার order আছে না? Delay continuation আছে? Yes, madam.
May I plead lordship? Lordship, this is an application under section 5 of the Limitation Act for continuation delay for 64 days.
Yes, MS Bora.
Maybe continue.
Okay, hard
A Pine.
A Paying. Learned counsel for the applicant appellant. NMS SH Bora, learned additional public prosecutor for the opposite party number 1, State of Assam. For subdivision application under section 5 of the Limitation Act 1963. Seeking condonation of delay of 64 days. Which is stated to have occurred in preferring the accompanying appeal against a judgment and order dated 22/02/2024 passed by the Court of Learned Special Judge, POXO. POXO where? You are so cryptic in your application. Making our task harder.
A special judge Sipsagar, lordship.
Now I have to look into this record. You have simply said POXO judge
Lordship, you said technical.
and
mistake.
not POXO, POCOSO.
Lordship, you said
So
typing.
careless. By the Court of Learned Additional Sessions Judge comes Special Judge within bracket POXO, Sipsagar within bracket the Special Court for short. By the judgment and order dated 22/02/2024, the applicant appellant has been convicted for the offense under section 6, POXO Act, and he has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 10,000. Come out default stipulation. Full stop. Is lady or
Open go lordship.
hello, POXO Harry Silo. POXO condonation of Harry to Silo. To Likilo. Yes,
This lordship.
the purposary. Legal aid counsel
Lordship, delay of 17 days.
Ah.
lordship.
and SH Boda. So appeal to. Judgment and order dated 16/5/2024. POXO case number 332 of 2023. Court hold 7
Paragraph 7, Lordship. Paragraph 7, Lordship.
Long
Page
paragraph.
9. Page 9, Lordship. Page 9.
Long
Lordship.
paragraph. To understand page 9, we have to read the paragraph.
Yeah,
Otherwise, how can I
page
pick up?
9, Page 9, Lordship, second line, June 2000,
But this is to be completed. We are not supposed to keep it CAB. Yes, Mr. Kolta. No, we have to start this.
Would it be possible to do so? We should-
If, no, we will continue. If it is not, we will roll over. But we will not keep it unfinished. Mr. Kolta, I don't think, I'll just see. What is your case otherwise?
Lately, one of the allegation that she, one of the two children, she administered poison. Actually, poison was all the family members consumed. Ultimately,
Gone through.
died.
Yes.
gone through.
One child was thrown away in Kolong River, another, he was found dead. She was on the bosom of the lady. She also consumed poison. Husband deserted.
Deserted 10 years ago due to starvation.
But
And-
offense is complete or not complete? That is the issue.
Actually, forensic
Yeah,
also
some about the.
report is there.
Yes.
And what is the other one? Some. Mr. Koila, some already.
What?
Not possible. No, itu aru to kipa asil na? MS Bhuiya, some already.
Fine.
We'll start this one. Oh, mention one. Who said that? Mr. A.K. Bhuiya. Mr. A.K. Bhuiya. Or morning.
Yes, my lord. Wait for an adjournment in this matter.
Have you gone to the case?
Lordship, little bit, my lord.
Little bit.
Yes, ma'am.
The appellant appeared to have committed murder with a seizure.
Yes.
Huh?
On
So
that-
seizure. Eyewitness?
Yes, my lord. EW3, my lord. Yeah, yes.
Yes, madam, eyewitness.
Eyewitness is there and corroborates with the doctor evidence.
Doctor evidence. When Mr. Bhuiya will be available?
Lordship, after a week, my lord. Maybe.
After a week. By stage.
21,
29.
1, or 29, 6, yeah.
20. Yes, ma'am.
29.
Yes.
MS
B. Bora.
B. Bora, Land Council, appearing for Mr. A.K. Bhuiya, learned amicus curiae has sought for an adjournment. Full stop. Ms. A. Begum, learned additional public prosecutor for the respondent state is present, list the case as sought for. Come list the case on 29.
I'm all this.
MS Begum was there or MS Bhuiya? Oh, that one. Two cousins.
Two cousins.
This criminal appeals. What colleague into open again? This criminal appeals from jails under section 383 Code of Criminal Procedure 1973, the code or CRPC. Oh, my head is directed against a judgment, an order dated 4/2/2021, passed by the Court of Learned Sessions Judge Jorhat at Jorhat, inspection sessions case number 184 within bracket C-T, page 50 of 2018. By the judgment, an order dated 4/2/2021, the accused appellate had been convicted for the offense of murder under section 300, Indian Penal Code IPC, and he has been sentenced under section 302, IPC to undergo rigorous imprisonment for life and to pay a fine of rupees 1,000, in default of payment of fine, to undergo simple imprisonment for another month. Full stop. It has been observed that a detention so-and-so during course of investigation, inquiry or trial will be set off in terms of section 428 CRPC. Full stop. Right, doctor. The case, sessions, case number so-and-so, arose out of Borhola Police Station case number 67 of 2018 and corresponding GR case number 430 of 2018. The first information report in connection with Borhola Police Station case number 67 of 2018 was lodged before the officer in charge Borhola Police Station on 28/2018 by one Zaro Biam Jaruar, within brackets, since deceased, as the informant. Full stop. In the said FIR, the informant had inter alia mentioned that at around 12 o'clock midnight, intervening 19/8/2018 and 28/2018, he found someone groaning from the house of Robihud, RABIHUD, Jajowar, ZAZOWAR. Hearing the groans, when he went to the house of Robihud Jarwar, hearing the groans, he found Robihud Jarwar lying unconscious in a pool of blood in the courtyard. And noticed a wound on his neck, appeared to have been inflicted by a sharp weapon. ভুল হয়েছে রবিহুড নহব অভিহুড হব ভুল হয়েছে গম পাইছেন রবিহুড ববিহুডের ট্রান্সলেশন ভুল করেছে I think it is wrong. Translation appears to be wrong. Huh?
That is why I'm citing.
Difficult.
Uh,
এর অবশ্যক নিদিব এইটো লাগিব পাৰে
RABIHUD, it's.
No, Robihud,
it's a
Robihud.
RA
No, it is accused who was lying unconscious.
That is lordship,
Fire exhibit,
Bihud.
it should be Obihud.
Abhi-
In the translation, it is Robihud. Hmm. But in the affair, it is Robihud.
That is.
Who is disease? Robihud.
In his, I saw that, they had taken
Hmm?
information. See, Rabiu Jajwar had died. It is right, in the house of sustained revenge inflicted by Sir.
Then if he is died, how can he be lying unconscious in a pool of blood in a courtyard? Courtyard is the accused.
Lordship, accused.
Court,
was
the accused was lying
in the courtyard. And he
Ah.
was in the
and he is cousin of both.
cousin of both. Lordship.
এনেকে সেইবোৰ লিখিব নালাগে এনেকে লিখক in the affair intervening so and so he heard groaning from the house of Robi Zarwar poster. Going there, he found Robihud Jarwar in a moribund state, full stop. The informant suspected that Obihud Jarwar, that is the accused, had hacked Robihud Jarwar, that is the deceased, to death with a sharp weapon. Full stop. Where on receipt of the FIR EXT5, the officer in charge Borhola Police Station registered the same as Borhola Police Station case number 67 of 2018 for the offense under section 302 IPC. and took up the investigation of the case himself. Full stop. Fair. It transfers from the materials on record that prior to lodgement of the FIR, the officer in charge Borhala Police Station, Deputy Fukan, PW 14, received a telephonic information from the VDP personnel of Sereli Gukhaigaon on 19/8/2018 to the effect that some unknown persons had assaulted one person in that village, and the assaulted person was lying in an unconscious state. Poster. It was further informed by the VDP personnel that they had informed 108 ambulance to shift an injured person. Oh no. To shift the injured person to the hospital for medical treatment. So it implies that VDP person did not see that man dead.
Inside the dead body. They have taken
Full
only the.
On receipt of the said telephonic information, the officer in charge Borhala Police Station registered the same as General Diary Entry number 281 dated 19/8/2018. Full stop. Immediately after registration of General Diary Entry number 281 on 19/8/2018, PW 14, along with his staff, proceeded to the village where the incident had Sereli Gukhaigaon, where the incident had occurred, and reached the compound of the house of the deceased, Robi Jajwar. Z-A nohoy sake, J-A-J-O. W-A-R, it were correct. And found Obhihud Jarwar lying unconscious with cut injuries on his neck and in a pool of blood. So sorry. As in the meantime, 108 ambulance service arrived at the place of occurrence, that is the house of the disease, Robi Jarwar, the injured person, Obhihud Jarwar, was shifted to hospital for treatment at Titabar Hospital. Post. It has further emerged from the testimony of PW 14 that when he, within bracket PW 14, entered into the house of Robi Jajuar, he found Robi Jajuar, within bracket the disease, lying dead in a pool of blood with cut injuries on his leg. Full stop. The incident was reported to the Superintendent of Police Jorhat, and a request was sent by PW 14 to the magistrate for holding inquest on the dead body of the deceased. Full stop. As PW 14 was informed that magistrate was informed that the inquest would be held only in the morning on the following day, he made arrangement for guarding the dead body under the supervision of his staff and with the help of the PDP personnel and villagers. Full stop. It was in the morning on the following day, that is, 20/08/2018, the informant Jajobian Jajuar lost the affair in the police station. FIR EXT5. The informant Jarobian Jajuar was the brother of the deceased, Robi Jajuar. Full stop. After registration of the affair, the statement of the informant Jarobian Jajuar was recorded in the police station. Full stop. Thereafter, the IO PW 14 proceeded to the place of occurrence and when the executive magistrate arrived at the place of occurrence, inquest proceeding on the dead body of the deceased was conducted on 28/2018. What is the inquest report? Full stop. After completion of the inquest proceeding, the at around 9 a.m. After completion of the inquest proceeding at around 9 a.m. on 28/2018, the executive magistrate Roman and circle officer Titabo Revenue Circle recorded his findings in an inquest report EXT EXT1. Full stop. The dead body was thereafter sent to Jorhat Medical College and Hospital for postmortem examination. Postmortem. After the arrival of the dead body in the JMCH at around 12 p.m., the postmortem examination of the dead body of the deceased was performed. And after completion of the postmortem examination, the autopsy doctor recorded his findings in the PME report EXT 4. In the course of investigation, the IOPW 14 recorded the statements of witnesses available at the place of occurrence and prepared a sketch map of the place of occurrence PO EXT 6. Full stop. The IO seized page 82. One or two, one yellow and black colored Blastane torch, or two Blastane copy down, page 82. Wide a seizure list, MR number 30/2018 within bracket EXT3 and 1 and 2, page 80. Wide another seizure list, MR number 31 of 2018 EXT2. Full stop. As the accused, Obihud Jajwar was also treated in the JMCH, the IO collected a medico-legal case report EXT 8 from the JMCH. Poster. After collecting the postmortem PME report from the JMCH and completing investigation into the case, so and so case number, the IO submitted the charge sheet under section 173(2) CRPC by charge sheet number 52/2018, dated 31/10/2018, EXT7, finding a prima facie case well established against the accused for the offense under section 302 IBC. Full stop. On receipt of the after submission of the charge sheet, comma. The learned subdivisional judicial magistrate M. T. Tabor secured the appearance of the accused Oviu Jarjoar from jail custody on 4/12/2018. Full stop. Finding the copies ready, comma, the same were furnished to the accused in compliance of the procedure laid down into section 207 CRPC. As the offense under section 302 IPC is exclusively triable by the Court of Sessions, comma, the learned subdivisional judicial magistrate M. T. Tabor, by an order of commitment dated 4/12/2018, committed the case records of GR case number 430 of 2018 to the Court of Sessions, Jorhat, for disposal. Full stop. The learned public prosecutor was accordingly notified. Full stop. The jail authorities were directed to produce the accused before the Court of Sessions, Jorhat, on 18/12/2018. Full stop. Para. On appearance on a receipt of the case records of GR case number so and so pursuant to the order of commitment, comma, the Court of Sessions registered the same as Sessions case number 184 JT of 2018. Full stop. Upon appearance of the accused before the learned trial court, learned trial. And after hearing the learned public prosecutor and the learned defense counsel, and upon perusal of the materials on record, comma, the learned trial court framed, comma, on 24/12/2018, comma, the following charge, page 6. When the charge was read over and explained to the accused, comma, the accused abjured guilt and claimed to be tried. Full stop. During the course of the trial, comma, the prosecution side examined 15 number of witnesses, page 74, and exhibited 7 number of documents, page 74. Full stop. In addition, comma, the prosecution also exhibited 2 material exhibits, page 74. Full stop. After closure of evidence from the prosecution side, comma, the accused was examined under section 313 CRPC, providing him the opportunity to explain the circumstances appearing against him from the evidence laid by the prosecution. First of the case of the plea of the accused was of denial. First of when the accused was asked as to whether he would adduce any evidence in his support, comma, he declined to adduce any evidence in his support. Full stop. After hearing the learned counsel for the parties and appreciation of the evidence on record, comma, the learned trial court delivered the judgment and order dated 4/2/2021, comma, impugned hearing, assailed hearing. Postal. We have heard MS M. Borman, learned amicus curiae, appearing for the accused appellant, and MS A. Begum, learned additional public prosecutor for the respondent state. Postal. MS Borman, learned amicus curiae, appearing for the appellant, has submitted that the case in hand is one resting on circumstantial evidence, as the prosecution had not any witness as an eyewitness. Postal. Though there were a number of witnesses who arrived at the place of occurrence, PO, that is, the house of the deceased, but nobody had deposed to the effect that they had witnessed the incident. Postal. MS Borman has further submitted that the accused from the evidence of materials from record, it would emerge that the accused was wrongly implicated, as he himself sustained a grievous injury in the alleged incident. Postal. The prosecution did not lead any evidence as regards the circumstance in which the accused had sustained the grievous injury. Postal. MS Borman has further contended that the obligation cast on the prosecution to lead reliable and credible evidence in respect of the circumstance was not found to have been properly discharged. And as such, there were many missing links, leaving the chain incomplete. Submitting so, learned amicus curiae has contended that the judgment, an order of conviction and sentence passed by the learned trial court calls for interference, and the accused appellant is entitled to the entitled to be acquitted. First of all. Or contrary, MS Begum, learned additional public prosecutor appearing for the state has supported the judgment and order of conviction and sentence passed by the learned trial court. By contending that the chain of circumstance is found, the learned trial court has returned a finding of guilt after finding the chain of circumstance to be complete. Full stop. It was the accused who stayed in the house of the deceased on the fateful night, and when the deceased sustained the fatal injuries, as mentioned in the as recorded in the PME report EXT4, inside his house, it was only the deceased who were the only other inmate in the house. And as such, in the case in hand, the rule of evidence embodied in Section 106 Evidence Act is clearly applicable. Full stop. The theory of lasting together is also relevant in the case. And in the absence of any proper explanation by the accused, in what situation the disease has sustained those injuries on his person, the same is a strong circumstance against the accused. Full stop. MS Begum has thus contended that the judgment and order of the learned trial court needs no interference. Full stop. We have given due consideration to the submissions of the learned counsel for the parties and have also produced the evidence took materials on record, including the testimonies of the prosecution witnesses and the documentary evidence, as available in the case records of so and so in original poster. We have also considered the decisions relevant, termed as relevant in the facts and circumstances obtaining in the case in hand. Full stop. As mentioned above, comma, the prosecution had examined 14 number of witnesses to bring home the charge of murder against the accused during the trial. Full stop. In addition, comma, one witness was examined as court witness, comma, CW1. One witness, comma, Dr. Nizamuddin Khan was examined as court witness, comma, CW1. Full stop. Out of the prosecution witnesses, comma, the prosecution witnesses dash PW 1, PW 2, PW 3, PW 4, PW 5, PW 6, PW 7, PW 8, PW 9, and PW 9 are inhabitants of village Sereli Gukhai Gaon. Full stop. Among them, comma, PW 7 and PW 8 are close relatives of the accused and the deceased. Full stop. The other prosecution witnesses is PW 1 or PW 6. No, like PW 10 is the autopsy doctor, whereas PW 11 was the circle officer, Titabo Revenue Circle, who conducted the inquest proceeding. Right? Oh, no. PW 11. He is the inquest one? Who conducted the inquest proceeding. Full stop. PW 12 was the then in charge, Bekajan police outpost, who accompanied the officer in charge Borhola police station, the IO PW 14 to the place of occurrence on 28/2018. Post. Who is 13?
Thirteen is another officer, Lordship.
Ayo.
I was the officer in charge.
PW 14 was the investigating officer of the case who completed major part of the investigation, and PW 13 was the subsequent investigating officer who, after completing the remaining part of the investigation, submitted the charge sheet EXT file. Right? CW1, Dr. Nizamuddin Khan was in the capacity of registrar JMCH, examined the accused, examined the injuries sustained by the accused on 20/08/2018 at JMCH. Post of para. From the evidence, from the testimonies of the prosecution witnesses, PW1 to PW9, it has emerged that the two close relatives of the accused and the deceased, PW7 and PW8, were the first ones, along with the informant, Jaro Biam Jajuar, within bracket since deceased, and one Rohit Tati, within bracket not a witness, who reached the place of occurrence, PO, that is the house of the deceased. Full stop. The prosecution witnesses there's PW3, PW4. From the testimonies of the prosecution witnesses, the prosecution witnesses PW3, PW4, and PW6 reached the PO after PW7 and PW8 and earlier than the prosecution witnesses, that's PW1, PW2, and PW5. Full stop. Fair. PW7, Elisara Jajuar is the mother of the accused, and she knew the deceased also, as the deceased was the son of her brother-in-law, within bracket Borjona. First up. PW7 also knew the informant Jorabian Jajuar, And in her testimony, PW7 stated that the informant had already died. Full stop. Deposing to the effect that the occurrence took place during the night hours on a day in August 2018, PW7 deposed that when on that day she was sleeping in her house, she was informed by the informant within since disease and Rohit Tati by coming to her house and waking her up. That some incident had occurred in the house of the deceased. Full stop. Accordingly, she, along with her daughter-in-law, Sandhya Jajuar, PW7, went along with the informant and Rohit Tati to the house of the deceased. Full stop. Going there, she saw her son, the accused, with a cut injury on his neck. Full stop. The deceased was found inside his house and she could see him lying inside the house through a gap in a door of that room. Gustav. PW7 further stated that the injured was taken to hospital in an ambulance. Full stop. PW7 further testified that on the day prior to the incident and on the date of the incident, she saw her son, the accused, in the company of the deceased. Full stop. When cross-examined, PW7 stated that she did not know how the deceased died or was responsible for the death of the deceased. Full stop. PW8, Sandhya Jajuar, who is the sister-in-law of the accused, deposed to the effect that deposed like PW7, deposed that the incident occurred in a night on a date in August, on a day in August 2018, post of PW8 stated that at the relevant time, she was sleeping in her house along with her mother-in-law, El Sada Jajuar PW7. Post of. It was then the informant, Jorabi and Jajuar, since disease, and Rohit Tati raised shouts from outside the house and wake them up. Post of. Immediately thereafter, she along with her mother-in-law, PW7, went to the PO, and going there, she saw the accused at the homestead of the deceased, shouting and calling, quote, quote, mama, within bracket, mother, mother. Also, she noticed country injury on the neck of the accused with blood oozing out from it. Post of. PW8 stated that she saw the dead body of the deceased from a distance after arrival of the police personnel at the PO. Post of. In cross-examination, PW8 stated that she did not know how the deceased had died. Madam Begum, tomorrow. All these miscellaneous cases took much of the time today. All eyes.
There were lots of cases also.
I will put them. Tomorrow, this will be taken up 10:30.